Good morning, everyone. Welcome back to LAB UAE. Still can't believe that I actually live in Dubai right now. Anyway, firstly, I want to apologise for my unmakeupped face. I came out in a really bad incident of prickly heat last week, which always happens when I go to a humid country, so I'm trying not to put anything on it, which probably means I look less than camera ready, but hopefully we can just deal with it and move on. Also, I've got a new camera lens and I'm not really sure what I'm doing with it. I'm kind of just struggling to get used to it. So this is probably going to be the worst video of all time, but hopefully you can just cut me some slack until I get used to my new surroundings and new equipment. Okay, today I wanted to talk to you about my first ever remote court experience. I've been kind of late to the party on this whole virtual court hearing thing because I managed to settle a load of my really big cases just before we went into lockdown, and those cases would have been in hearings and trials and stuff over the summer, but obviously they settled, so those didn't go ahead. The other half of my cases have pretty much been delayed by COVID because we've had to agree stays in proceedings and extensions. As you know, all of my cases are cross-border cases, so they involve multiple different people and representatives in multiple different jurisdictions who are all in various different levels of lockdown and inhibited in terms of the court process. So it has been pretty slow going over the summer in a lot of my cases, but last week I was listed for my first ever remote costs and case management hearing. So for those of you who aren't familiar with civil litigation, a costs and case management hearing is basically the first hearing that takes place in a case after you've issued proceedings, and the purpose of that hearing is to decide a timetable for the rest of the case, basically. So what evidence will be exchanged and when, right up until the point of a final trial. Normally the parties will try and agree in advance what the timetable should be, and sometimes if you can agree on everything, then the hearing doesn't have to go ahead before a judge. But more often than not, there's one or two things which the parties can't agree on, and then it has to go before a judge so the judge can make a decision and order the timetable. So this is what happened to me last week. This is one of my cosmetic surgery cases, and this is a slightly unusual case because this didn't actually take place at the beginning of the case because there were a load of preliminary issues in this case that the court had to decide before we actually got to this stage of CMC hearing, as they're called. But it was quite an interesting experience, and I thought I would share it with you and some of the things that I learned in case any of you who are paralegals or current trainees might have experience of this over the next year or so. First tip, read your order which is listing the virtual/remote cost and case management hearing really carefully, because quite often they are all different depending on what judge you're in front of, what court you're in, what type of case it is. So don't assume that if you've had another virtual hearing before this, that this is going to be exactly the same. Read it really carefully because all the information you need will be in that order. It will either give you really specific instructions of how to file things, when to file things, what type of format they want documents in, or it will direct you towards a part of the civil procedure rules which you need to follow. So all of the information is in there. Just read it really carefully as soon as you get it, because you should have quite a bit of notice of the hearing. So if you do need to do things a week, 10 days, 3 weeks in advance, which is the case with some hearings if you need to file a budget, then you can diarise all of that really well. So just make sure you read it super carefully and put any important dates in your diary. With my cases, because I'm quite often dealing with foreign defendants, I always serve a copy on my opponent as well. The court should do this, so you don't need to do it unless the order specifically asked you to, but I normally do it as a matter of caution anyway, just so that if your opponent fails to file things or fails to turn up on the day, that they've got no excuse for doing so because you've already served them. But again, that is quite specific to my line of work because I'm dealing with foreign defendants. In the current climate, it's also really important to check in advance that you have all of the documents that you need accessible to you to put in a bundle. In my case, there are a couple of original orders which I didn't have digital copies of, and I therefore needed to make inquiries with the office about how to get copies of those original documents emailed to me. So again, that's just a lesson in making sure you prep in advance to make sure you're not scrabbling around last minute trying to find documents and serving things late. Obviously, it goes without saying to file things on time and in the proper way. It's not a good look to be filing things late or not in accordance with the order, and it just gives your opponent more ammunition for their arguments if you fail to comply with things and you haven't done things in the right way. Litigation is a tactical game, and your opponents will use literally anything against you to try try and get the judge on their side, so just be mindful of that. Normally it's up to the claimant to take the lead on routine hearings like this, so normally you will be responsible for collecting all of the details for the remote hearing from the court. In my case, the court were happy to set up the meeting, which took place via Microsoft Teams, which is what the court are using these days for all of their remote hearings, as far as I know. But it will be up to you, if you're the claimant, to actually gather all of the details for all the parties. Again, there's something a bit niche about my cases because I'm not dealing with sophisticated litigators in some cases, so I had to check that actually all of the people involved in the hearing had Teams suitable email addresses, which is basically an Outlook address. But again, that's something worthwhile checking in advance because your parties will need to get themselves an Outlook compliant email address if they don't already have one. In terms of the hearing itself, normally the court will send you your invitation to join the Teams meeting, which is fine. You diarise that and join that maybe 2 or 3 minutes ahead of the conference, just to make sure you've got no technical issues with joining. There were some technical issues, not on my part, but with some of the parties involved in my hearing. So we ended up not starting the actual meaty part of the hearing until about 20 minutes in, which then resulted in us not getting through everything on the day and delays and things like that. So just try and make sure that at least for your part, you log in a few minutes in advance to make sure you're all set up and you're not the one causing the delay, because you don't want to give the judge any reason to not be in your favour. If you are not the one doing the actual advocacy, i.e. you've instructed a barrister or counsel, make sure that when you join the Teams meeting, your mic and camera are off. On Microsoft Teams, it will normally ask you that before you actually join the meeting, so just double check that those are ticked, because you will not be required to speak or be seen unless you're spoken to directly by the judge, which is unlikely to happen if you've instructed counsel. So just make sure those are off and you only unmute them if you're spoken to directly by the judge. Don't do what I did, which is start speaking when a question was directed at the claimant. I don't know whether it's just me, but in physical hearings, it's very easy to see that the judge is directing a question to your counsel because they're looking at your counsel. But when you're just looking at a screen and all you can see is the judge, and the judge is asking a question which you can answer about your case, my gut reaction was to answer. Luckily, I very quickly corrected myself and deferred to my counsel and did not touch the microphone for the rest of the hearing. But just be mindful to override your gut reaction to questions that I directed to you if you have counsel representing you. Another difference between virtual hearings and physical hearings is that you can't very easily communicate with your counsel. Normally in a physical hearing, you can tap them on the shoulder, whisper in their ear, pass them a note. You can't do that in a virtual context because although there is a chat function in Microsoft Teams, everybody can see that, which may not be ideal. So it's a good idea to either set up an email chain or a WhatsApp group. If it's easier, just check with your counsel how they would prefer to communicate with you, because you will need an open line of communication. Almost undoubtedly, there is always something you want to say to your counsel at some point during the hearing. Final word of advice is to dress appropriately, albeit that I've just said to keep your camera and microphone off during the hearing. There may well be an occasion where the judge needs you to come on screen for some reason. You just never know. So make sure that you're prepared to do that. Also, Microsoft Teams, as far as I know, doesn't have a virtual background facility. So again, just make sure you're in a suitable environment and suitably dressed on the off chance that you do need to be seen or speak. That's all the tips I have from my virtual court hearing experience. I hope that's been helpful and that you've learned something from this video that you can take away with you. If you've enjoyed this video, you know the drill. Hit like, leave a comment, and don't forget to hit subscribe. See you next time, guys.